All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. We just swap.
Good morning, everyone. And I would like to welcome parties and participants, as well as Mr. Musaula, to the first status conference of this case. Regarding the witnesses you intend to call, the Chamber understands that you cannot disclose what kind of witnesses you are calling. It all depends on the security issue. But can the prosecution give the Chamber the idea of approximate number of witnesses it intends to call?
Certainly, Madam President. Prosecution is looking at a figure of between 25 to 35 witnesses, Your Honors.
Is the point that the prosecution is not ready now for trial, but the prosecution will be ready after the end of the year?
In accordance with the position that has been advanced by prosecution in our sister case yesterday, we have also made our submissions in the light that, for the reasons that we've already discussed, we believe that it is best that the two cases are synchronized. So even though we could be ready for trial at the end of this year, for the reasons that we would go into further details when we discuss at the expertise session, we believe that the cases should be synchronized. That would be my response, Your Honor.
Thank you very much.
Well,
may I now return the floor to Mr. Khan?
Madam President, I'm most grateful. I thought for a fleeting moment we were getting some clarity, and I understood that my learned friends were saying that absent witness protection issues, absent disclosure rulings from the bench, they are trial ready. That's what I understood the position to be. The reason I say for a fleeting moment is in answer to the last question from the learned judge, my learned friends have mixed apples and oranges, because it seems that the delay is linked to a policy argument that was raised by the prosecution in a different case yesterday, when they said that they wanted to make this the twin of Kenya case number 1, and somehow matters should be synchronized. Your Honours, I would like to get further clarity on this issue. Have I understood the prosecution's position to be that absent witness protection concerns and absent disclosure rulings from the bench, they are trial ready now? Your Honour, that clarification on this critical issue would be much appreciated, and I'm sure it will inform all parties' discussions to make this status conference meaningful.
Mr. Khan, I think prosecution may be not absolutely clear, but relatively clear, if I may say so. What I understood from what prosecution said is that they are ready, except for their disclosure obligations and security concerns issue. And the only reason why they refers to this synchronization with other trial, again, is something to do with witness security and disclosure. Am I right, prosecution?
Yes, Your Honor. Your Honor is in line with submissions in this regard, that our primary, we can be ready at the end of this year, but we have issues of disclosure, of redactions, of witness security, which we're going to go into further details about. And finally, because we believe that as a policy, it is best that the two cases are synchronized. That's our position, Your Honor.
Our position is that we want a trial as soon as possible, without delay. Ambassador Mathaura, who sits behind me, is 65 years of age. After the confirmation decision, after more than 3 decades serving the Republic of Kenya as a diplomat and then as head of the public service, he stepped down. And in this part of his life, in retirement, he wishes to remove this stain that this case has spilt on his character as soon as possible. Your Honours, it is not good enough, in the respectful submission of the defence, for the prosecution to hide behind perceived policy issues, policy concerns. It is the position, Madam President, Your Honours, that these policy concerns, these policy imperatives, cannot trump the legal statutory right that Ambassador Mathaura has for a fair and expeditious trial.
Thank you very much. The next clarification I'd like to have is with regard to this suggestion by the prosecution for synchronizing with the other case. The prosecution mentioned to security concern. Well, actually, prosecution said it is because of the security concern that they want this synchronization. But on the other hand, what I understood from your submission is that the defense also wants this synchronization with the other case, not because of security concern, but because of their own reason, which is in accordance with the chronology of the events on the ground.
Absolutely correct. The narrative of the case is important, and it takes a journey some 6 months before these events occur. The prosecution case is that Kenya 1 then started, Kenya 2 later happened. And that's a very important issue within these proceedings. And it would be, in my submission, something not prosecution have mentioned, but if I was prosecuting this case, I would be ensuring that the narrative was before Your Honours rather than putting Part 2 before Part 1, as I can see that a case would gradually go into directions that it had no need to go into if it had been properly put together in the way as described by the prosecution with this synchronization. I'm not enamoured of synchronization, but the fact of the matter is Kenya 1 needs to be considered first because it's important for the factual matrix.
So just to conclude the discussion related to the start date of trial and disclosure and redaction, the Chamber plans to issue an order on the schedule for trial along with the relevant disclosure deadlines before the start of the summer recess.
All rise. We will go back.